Untouchables or the Children of India's Ghetto by Babasaheb Ambedkar. Part 2, Chapter 7. 1. While lawlessness is lawful, the foregoing discussion must have made clear two things which must be borne in mind. One is the sharp division between the touchables and the untouchables, and the other is the deep antagonism between the two. Every village has two parts, the quarters of the touchables and the quarters of the untouchables. Geographically, the two are separate. There is always appreciable distance between the two. At any rate, there is no contiguity or proximity between them. The untouchable quarters have a distinct name, such as Maharwada, Mangwada, Chamroti, Khatkhana, etc. De jure for the purposes of revenue administration or postal communication, the quarters of the untouchables are included in the village, but de facto it is separate from the village. When the Hindu resident of a village speaks of the village, he means to include in it only the caste Hindu residents and the locality occupied by them. Similarly, when the untouchable speaks of the village, he means to exclude from it the untouchables and the quarters they occupy. Thus, in every village, the untouchables and touchables form two separate groups. There is nothing common between them. They do not constitute a folk. This is the first thing which must be noted. The second thing to note with regard to this division of the village into two groups is that these groups are real corporations which no one included within them can escape. As has been well said, the American or European belongs to groups of various kinds, but he joins most of them. He, of course, is born into a family, but he does not stay in it all his life unless he pleases. He may choose his own occupation, residence, wife, political party, and is responsible, generally speaking, for no one's acts but his own. He is an individual in a much fuller sense, because all his relationships are settled by himself and for himself. The touchables or untouchables are in no sense individuals because all or nearly all of his relationships are fixed when he is born in a certain group. His occupation, his dwelling, his gods, his politics are all determined for him by the group to which he belongs. When the touchable and untouchable meet, they meet not as man to man, individual to individual, but as members of groups or as nationals of two different states. This fact has an important effect upon the mutual relationship between the touchables and the untouchables in a village. The relationship resembles the relationship between different clans in primitive society. In primitive society, the member of the clan has a claim, but the stranger has no standing. He may be treated kindly as a guest, but he cannot demand justice at the hands of any clan but his own. The dealing of clan with clan is a matter of war or negotiation, not of law. And the clanless man is an outlaw. In fact, as well as in name and lawlessness against the strangers is therefore lawful. The untouchable, not being a member of the group of touchables, is a stranger. He is not a kindred. He is an outlaw. He cannot claim justice, he cannot claim rights which the touchable is bound to respect. The third thing to note is that the relationship between the two, the touchable and untouchable, has been fixed. It has become a matter of status. This status has unmistakably given the touchables a position of superiority vis-a-vis the untouchables, and the untouchables a position of inferiority vis-a-vis the touchables. This inferiority is embodied in a code and of social conduct to which the untouchables must conform. What kind of code it is has already been stated. The untouchable is not willing to conform to that code. He is not prepared to render unto Caesar what belongs to Caesar. The untouchable wants to have his relationship with the touchables by contract. The touchable wants the untouchables to live in accordance with the rules of status and not rise above it. Thus, the two halves of the village, the untouchable and the touchable, are now struggling for resetting and resettling what the touchable thinks is settled forever. The conflict is centered around one question. What is to be the basis of this relationship? Shall it be contract or shall it be status? This raises some very interesting questions. How did the untouchables come to have the status of the lowliest and the low? Why has the Hindu cultivated this hostility and contempt for the untouchables? Why does the Hindu indulge in lawlessness in suppressing the untouchables as though such lawlessness is lawful? To give an adequate answer to this question, one has to go to the law of the Hindus. Without a working knowledge of the rules of Hindu law, it would be impossible to give any satisfactory answer to this question. For our purpose, it is not necessary to cover the whole field of Hindu law in all its branches. It is enough to know that branch of the Hindu law which may be called the law of persons, or to put it in non-technical language, that part of the Hindu law which deals with differences of right, duty, or capacity which result from differences of status. It is therefore proposed to give a catalogue of the rules of the Hindu law which relate to the law of persons. These rules are collected from the law books of Manu, Yajnavalkya, Narada, Vishnu, Katyayana, etc., who are some of the principal lawgivers recognized by the Hindus as persons having authority to lay down the law. A mere reproduction of the rules, however interesting, cannot be helpful in enabling a person who goes through them to have an idea of the basic conceptions which underlie the Hindu law of persons. For that purpose, mere reproduction of the rules will not do. Some order is evidently necessary. What is therefore done is to group these rules under certain heads. The whole thing is cast in the form of a digest divided into sections, each section being an assembly of rules dealing with one definite matter. The end.